Hi, good evening, everyone. We will be starting with the gamut of laws applicable to hospital. Every doctor must be aware about. Nowadays, there are a number of CMEs or symposia regarding the medical legal applications for doctors, but there are less of the sort of thing that we are having, and there are less CMEs which gives us an practical applications of the medical legal compliances as far as hospitals are concerned. So I will be speaking about the gamut of the laws. There are a number of laws which are applicable to the medical field. So we doctors are busy with treating patients, and the myth is that legal compliances are to be dealt by the administration or administrative people only. Every day, we all healthcare providers treat patients medically and are bound by the legalities. Every word you write on the paper is bound by the any sort of legal sort of things. You should be aware of the about the legalities or legal compliances. So at UG and PG curriculum, we barely touch legal aspects of the day-to-day medical practice. Forensic medicine and toxicology teaches us doctors as an expert witness, medical jurisprudence, and toxicology. In today's changing times of patient and relatives who are well informed, there are increased litigations, and of course, there are changing perceptions of the society, politicians, and governments towards the doctors. So we must be aware about the medical legal compliances. So this and disclaimer, I'm not a legal expert. I stand corrected in case of any lacuna in the information. Different states have different regulatory authorities, and there may be slight difference between the implementation of the many laws, regulations from state to state. Just to have an a history, in the world's first known medical legal compliance or laws applicable to the medical field are the Code of Hammurabi. Then there is an Hippocratic oath. There is Charak Samhita as far as Indian context is there, and there is the modern Hippocratic oath, that is the Declaration of the Geneva, which all of us are binding. And then there is a Medical Council Act 1933 and Bombay Practitioners Act 1938. And present status, there are various medical councils, National Medical Council, State Medical Council. There are rules and regulations also there, and there are various criminal as well as civil laws which are applicable to the medical field. So there are certain prerequisites for the medical practices. So we have to get registered with the state medical state medical councils for the practicing, and there are of course state medical councils having an powers of suspensions in case of professional misconduct is there. So these are the two things which I just wanted to mention in emergency and healthcare and law. Not only the government hospitals, private hospitals must give treatment in case of emergency if someone is dying, and there are two cases in the Honorable Supreme Court which are mandated: Katra versus Union of India in 1989 and Paschim Bengal Khet Mazdoor Samiti versus State of West Bengal in 1996. And they said that treatment comes under the fundamental right under the Article 21 of the Constitution. So denial of treating any in case of any emergency violate the right to life guaranteed under the Article 21. So certain criminal liabilities are there in the medical profession, lapses in the treating patient causing harm to the patients leading to the application of the Indian Penal Code, and offenses applied are the simple grievous hurt, murder, miscarriages, abortion, etc. And there are certain defenses for the doctors as also. Other speakers are going to speak on detailed on these things. We will not go into the details like informed consent or necessity, good faith cause are also there. So what is the spectrum? Spectrum laws governing to the hospital is the large spectrum of laws which are applicable to the as far as whole of the medical hospital systems. There are these sort of laws are applicable, and there are certain licenses, certificates required for the hospitals, and of course there are periodic reports. We will just enumerate all these exhaustive list of laws which are applicable to the governing of the hospital. So for the commissioning of the hospital, what these laws aims at the due process of registrations, and they also see that facilities are safe for the public use or for the anticipated workload, and there are periodic inspections for the compliances. So this is an exhaustive list of laws applicable for the commissioning of the hospital, including atomic energy, lift and escalators law, Companies Act, electricity rules, electricity regulations, Radiation Protection, Societies Registration Act. All these laws are applicable for the commissioning of the hospital. There are certain laws which are governing the qualification and practice and conduct of the professionals, and these law ensures the staff employed are authorized and qualified, and they are skilled. Their credentials are verified in the respective registration council. So Indian Medical Council Act, Indian Medical Degree Act, Nursing Council Act, Nursing Council Act 1997, Dentist Act. For the technicians, there is AICT rules. For the paramedical and physiotherapy, there are central physiotherapy councils. For the pharmacists, there is Pharmacy Act and Apprenticeship Act. Laws governing the sale and storage of the drug and safe medications. These law ensures controlled use of drugs, chemicals, blood and blood products. It regulates the sale of drugs through the licensing and prevent adulteration, and it mandates misuse of the punitive actions under the offenders for misuse of the dangerous drugs or any contraventions to the law. So there is a list of laws which are applicable as far as governing the sales and storage of the law, like blood bank regulation act, drugs and cosmetic act, excise permit for the store of the spirit. Yeah, and there are certain Indian penal codes applicable for the adulteration of the drug or sale of the adulteration of the drug or sale of the drug as different drug preparation and negligent conduct with regard to the poisonous subject. Then there are Narcotics and Psychotropic Substance Act, Pharmacy Act, Sales and Goods Act. All these laws are applicable for the sales and storage of the drugs and for the self medications. There are certain laws which are governing the management of the patients. They are for the setting of the standards and norms for conduct of medical professional practice. They are regulating the prohibiting performance of the certain procedures, prevention of unfair practices, and control of public health problems and epidemic, and also deals with the emergencies, medical legal cases, and all aspects related thereto, including dying declaration, conduct of autopsies, and various types of professional negligence. So, what are these laws? These are laws of contract, Laborers Act, Guardians and Ward Act, Drugs and Magic Remedies Act, Transport Act, or PC and PNDT, Medical MTP Act, and Mental Health Act. These are the laws applicable for the management of the patients. And there are certain laws which are governing the environmental safety also. These laws are aimed at the protection of environment to the prevention of air, water, surface, and noise pollution. And of course, there are punishment for the offenders. So, Air Prevention Control and Pollution Act, Biomedical Waste Handling Rules and Regulations, NOC for the Pollution Control Board, Noise Pollution, Public Health Bylaws, Water Act, that is Prevention and Control of Pollution. Then there are various municipal laws which are pertaining to the municipal corporations. Of course, there is law regarding the cigarette and other tobacco product prohibition of advertisement and regulations. And there are certain Indian Penal Code Act, that is making atmosphere noxious to the health, or negligent act likely to the spread of the infectious disease dangerous to the life, and unlawfully or negligence. There is a huge list of laws which are applicable for healthcare or hospitals regarding the employment and management of the manpower, and it deals with the regulation of the employment of manpower, their salaries, benefits, service rules, etc. And of course, there are system of redressal of grievances and disputes. So we all know about the ESIC Act, ESIC rules, or Employee Provident Fund rules, SHOP Act, Bombay Welfare Act, Citizen Act, TDS, or SC and ST Act, Shops and Factories Act, Negotiable Instrumentation Act, Payment of the Bonus, Gratuity, and Wages Act. These are the laws which are applicable for the governing of the employment and management of the manpower. So laws regarding the governing of the legal aspects, there are certain laws, and we all know about the Consumer Protection Act or Indian Evidence Act, Law of Torts, and there are certain Indian penal codes of applicable for the good faith, accident in doing lawful act, or insane and for insane and children. There are certain Indian penal code sections are applicable. So these laws are regarding the governing of the doctor-patient relationship, legal consequences of the breach of contract, and medical legal aspects of the negligence of the duty. And then there are laws governing the safety of the patients, public, and staff within the hospital premises. And these laws pertains to the safety of facilities and services against any accidental hazard that may endanger the lives and liability of the management for any violations. And this is an exhaustive list of laws. And there are certain Indian Penal Code sections also applicable to the safety of the patients, public, and staff within the hospital premises. There are certain laws which are governing the training and research. Those institutions which are giving training are like nursing training or DNB or undergraduate or postgraduate training. So these laws uh, mean to regulate the standard of the professional education and training of doctors, nurses, technicians, and controlling of the research activities per se. Then there are certain laws which are applicable as a business aspect, like Cable and Television Network Act, Charitable and Religious Trust Act, Contract Act, Copyright, Custom Act, FEMA Act, Gift Tax, Income Tax, Insurance, and GST also is applicable. There are certain licenses and certifications required for the hospital, and there is an exhaustive list of licenses and certifications which are applicable, like registration under the Societies Act initially, or inspection of the electrical installations, substation, NOC from the local municipal corporation, or a license for the storage of the diesel, or income tax exemption certificate, drug licenses for the medical store, IPD pharmacy or OPD pharmacy, and licenses for the blood bank, or registrations on the PSCP NDT, fire services, or the also is applicable to us. So these are the various laws which are applicable for the licenses and certificates required for the hospitals. And continuation with the list, like VAT or Employee Provident Fund, USIC Coverage Act license is also there. MTP registration, fire safety or B form is there. Authorization for generation of biomedical waste handling rule is there. And for the lift, there are certain rules and regulations for operating the lifts in the hospital. So there are certain periodic reports and returns for the legal commitment, biomedical generation reports, income tax annually has to be there. PC and PNDT Act is there, and one or unit process of the blood bank monthly has to be submitted. Then there is MTP report monthly, or a registration of birth and deaths, like, and or of course communicable diseases reports has to be communicated with the appropriate authorities. So coming into the nutshell, I have compiled all these laws. As in general, if we look at these laws, we will not come to a conclusion what should be done on day to day. So there are, I have compiled in this slide that there are certain civil laws, there are criminal laws, and laws specific to the medical field. These are laws applicable. So we can classify law application, legal compliances, practical application is certain laws of, for the clinical processes, for the non-clinical processes, for the administrative processes, and for the infrastructures. So for OPD, IPD, at every step, there is law applicable to us. So there are periodic reports and day-to-day documentation is there. So in coming lectures, we will be dealing with certain these things, sort of things. So we have compiled 5-6 module course for the day-to-day compliances, And if anyone is interested, please write to us so that we can move ahead with these modules. And that will be spanning over a period of 4 to 6 weeks for 2 days for 2 hours at least. So these are the modules which we propagate, and everyone will be provided with the detailing of the day-to-day application and detailing of the day-to-day actual how to do it. Like for OPD paper, what is the ideal OPD paper? How it should be the surgeon's note? What is there to be? What are the register which are to be maintained in the operation theater or in a labor room? Or what care all should be taken while implementation of an hospital? So what is the MLC? How medical records or consent has to be done? What are the ART or SROBC rules? What are the telemedicine rules and regulations? Like for the administrative rules, these are the all administrative sort of day-to-day compliances we are going to teach in these modules. And certain some of the topics are going to be covered by Dr. Ajay and Dr. Iqbal in forthcoming lectures. So thank you. Most common medical legal situations arise out of non-compliances of these rules and regulations. If a doctor or a hospital acquaints well with these rules regulations and follow them sincerely, he or she would be on the right side of the law. So thank you very much for your patience hearing. Next lecture is by Dr. Iqbal Minne sir, and he is He's a radiologist, medical legal consultant. He is MBBS, DMRD, DMRE. He is BGL, LLB, and LLM also. He is based at Aurangabad. He is also an medical legal consultant. He guides doctors in legal issues. His gold medalist for the diploma in medical jurisprudence and forensic medicine. And Dr. Iqbal sir, please unmute yourself. Unmute yourself, sir. You are not unmuted yourself.
इझी फोनवरून प्रेझेंट करतात का सर? त्यांचा आयपॅड आहे का?
iPad, yes.
हा मग सर तुम्हाला ते स्टॉप शेअरिंग करावं लागेल. प्रमोद सर.
मी का? ओके.
हा मिन्ने सर आता करा तुम्ही शेअर.
Am I audible?
येस
Yes, sir. Yes, you are audible. Please.
सर शेअर
share
स्क्रीन
your
केलं ना की तुमचं प्रेझेंटेशन चालू होईल. वरती रनचं बटन आहे.
शेअर कर.
शेअर स्क्रीन खालचं ग्रीन बटन शेअर स्क्रीन बॉटम लाईन.
Is it on?
येस स्टार्टिंग. एक मिनिट होतंय.
So now you just need to open the PowerPoint.
Yeah.
सरांचं नेट थोडं स्लो दिसतंय.
नाही, वायफाय गेला होता माझा.
हा तेच म्हटलं.
लाईट ऑफ झाली ना.
करेक्ट. सुरू झालं सर. बेस्ट.
Okay. Good evening, everyone. I'm Dr. Iqbal Minne. I'm based at Aurangabad. Thank you, Pramod, for introducing me. Now we're going to deal with the sudden and unexplained death. In this situation, doctors may not be panicked. So first thing is that you should not be panicked. Now, what is the agenda? In this, we are going to talk about the introduction, the general guidelines, and best practices we follow, and the legal aspects, and a case study, a small case study we are going to do. The next is, now in this introduction, when sudden or unexplained patient's death is there in the hospital, one can have significant legal implications for healthcare professionals and institutions. The importance of understanding legal responsibilities and procedures. The healthcare providers must be aware of the legal obligations and the steps to take in such situations to ensure compliance with the law and mitigate potential risks. Now, what are the general guidelines for managing sudden death, or if the dead person is found in cases where what you have to follow? First of all, we will see what are the types of the deaths. The deaths requiring medical legal investigations are categorized into three main groups. Number one is deaths known or suspected to be caused by unnatural causes. Secondly, sudden deaths with unknown causes, and cases where individuals are found dead or termed as unattended deaths. There is an international classification of sudden deaths. What happens is, usually when we see sudden death in our hospitals, or if a dead body is brought in our hospital, or the person is brought in our hospital or the clinics and the patient is already dead, then we get panic. So we need not be panic, because the international classification also that. So what are these? So according to the international classification of diseases, that is ICD-10, sudden deaths and with the unknown causes may be classified as R96, that is instantaneous death. R96-1 is a death occurring within 24 hours of onset of symptoms, which is unexplained. R98 is death where no cause could be discovered despite finding the body. In R99, deaths with unspecified causes. Now, deaths due to natural causes fall under the medico-legal domain, where when they occur in the certain circumstances such as custody clashes, accidents, or violent arguments. In such cases, a post-mortem examination is required before certifying the cause of death. Upon encountering the sudden death, the attending medical officer or the doctor will conduct a of the disease and initiate the resuscitation if applicable. If resuscitation efforts fail, the death will be confirmed and the necessary procedures will be followed. Two identification marks of the deceased will be noted, and circumstances leading to death will be ascertained from the individuals bringing and identifying the body. Now, what is the duty of the doctor in such cases? The first is the explanation of the duty of the care. The healthcare professional, that is the doctors, owe a duty to care the patients, which entails providing a standard of care consistent with the professional norms and the practices. Now, what are the legal obligations? This duty is legal obligation that forms the basis of the doctor-patient relationship and extend to all aspects of patient care, including diagnosis, treatment, and monitoring. Now, what should be your first response? That is immediate action. What you should do. In the event of sudden death or unexplained patient death, healthcare providers, that is doctors, must take immediate action, including contacting appropriate medical authorities and preserving the scene for investigation. What is the importance of the prompt response? The quick and efficient response is crucial for ensuring the preservation of evidence and facilitating the investigating professor. Now, what are the legal documents you require? Accurate and timely documentation. Usually we see hospitals or the doctors, they fail in documenting. So accurate and timely documentation of the events leading up to the patient's death is essential for the legal purposes. The documentation requirement, what are the requirements? Medical records, treatment plans, and any relevant communication should be carefully documented to provide a comprehensive record of the patient's care. Now, the first and foremost important is communication with the family. Here we feel, it is my observation, most of the times we care for the patients, we attend them in time, we give all the services. But in spite of that, when there is a death, we get fumbled and we get panic and we fail to communicate. You must see that when we are communicating with the patient, patient's relative must be satisfied that doctor is doing something to save the life of the patient. That patient's relative must also observe this and they should know about it. So what are the guidelines? So healthcare providers, that is a doctor, should communicate with the family of the deceased patient with empathy, transparency, and sensitivity. Now, what information you should provide? The family should be provided with a clear and honest information about the circumstances of the patient's death while respecting their emotional needs and cultural sensitivities. Now, after the death, you have got some obligations to be reported to some of the authorities. Now, what are those authorities? Healthcare providers have legal obligations to report sudden or unexplained patient's death to relevant authorities, including medical boards, health departments, and law enforcement agencies. Now, what are the procedures for that? Procedures for the reporting should be followed in accordance with the applicable laws, regulations to ensure compliance and facilitating investigations. Now, what are the legal investigations and who are involved in this? First of all, legal investigations may follow sudden or unexplained death, especially the police, involving medical boards, regulatory bodies, and law enforcement agencies, that is police authorities. And what are the determining causes and liabilities? The investigations aim to determine the cause of the death and identify any liabilities or negligence that may have contributed to the patient's death. Now, many times, if the patient has is dead within 24 hours of the admissions or bringing to the hospital, then when the cause of death is not known, at that time, autopsy or post-mortem examination must be done. So it is necessary in case of the sudden deaths, unexplained deaths, to determine the cause of the deaths. Now, what are the legal requirements and the procedures? The doctors must follow the legal requirements and procedures for obtaining consent and conducting examinations in compliance with the applicable laws and regulations. Now, when you will be in trouble, when somebody will see that you are negligent or you are liable, then you are liable. What are the potential liabilities? The doctors may face liabilities and negligence claims in case of sudden or unexplained patient's death, depending on the factors such as standard of care, documentation, and adherence to the protocols. Now, what are the legal considerations? The legal standards and principles will be applied to assess liability and determine the extent of legal responsibility. Now, suppose you get the litigation and you are liable for that. Then at that time, you have a legal defense available also. So what are the available defenses? So if suppose somebody has claimed something, you need not be panicking, you need not be worried. You must face it boldly. So what available defenses are there with you? The doctors, the health providers, that is, facing allegations of negligence or malpractices, have legal defenses available to them, such as demonstrating adherence to the professional standards and guidelines. What is the importance of legal representation? Legal representation can help healthcare providers, that is doctors, to navigate the legal proceedings and mount a strong defense against the allegations. Now, I have taken one case study. Now, I have labeled it as Hospital X, and I have taken the patient's name as Kumar and the doctor's name as Ravi, which is common. So in one of the case study, so just for your instance, for explanation, Hospital X is a leading healthcare facility in metropolitan city in India. Now, Dr. Ravi is the senior surgeon in this, and he performed a routine surgery on Mr. Kumar, who is a 45 years old patient. However, shortly after the surgery, Mr. Kumar experienced complications and unexpectedly died. Now, what are the events leading to the incidents? Dr. Ravi performed laparoscopic cholecystectomy on Mr. Kumar, and he removed the gallbladder as well as gallstones. The surgery proceeded without any apparent complications, and Mr. Kumar was transferred to the recovery room. In the recovery room, Mr. Kumar complained of severe abdominal pain and difficulty in breathing. Despite immediate medical interventions by the hospital staff, Mr. Kumar's condition deteriorated rapidly and he succumbed to his injuries within an hour of the surgery. Now, what are the legal implications in this case? Number one is the first information report, that is FIR. Mr. Kumar's family filed an FIR at the local police station alleging that medical negligence resulting in his death, the negligence was done by Dr. Ravi. The FIR outlined concern regarding the surgery, post-operative care, and the hospital's response to Mr. Kumar's deteriorating condition. The next step was autopsy and post-mortem examination. The police ordered an autopsy and post-mortem examination to determine the cause of Kumar's death. The examination revealed complications related to internal bleeding and organ perforation during the surgery, leading to fetal consequences. What are the legal investigations that done in the Kumar's case? The medical board and the health department launched investigations into the incident, reviewing Dr. Ravi's surgical records, hospital protocols, and the event of surrounding Mr. Kumar's death. The investigations aim to ascertain any instances of negligence or deviation from the standard of medical practices. Now, the liabilities and negligence claims. Dr. Ravi and ex-hospital face potential liabilities and negligence claims due to the allegations of the medical negligence. Factors such as surgical errors, inadequate post-operative monitoring, and delay in responding to complications were examined to determine liability. Now, what are the legal defenses available to Hospital X and to Dr. Ravi? Now, Dr. Ravi and Dr. X and Hospital X asserted legal defenses, including adherence to established medical protocols, proper documentation of the surgery and post-operative care, and absence of intentional wrongdoing or gross negligence. Legal representation was also sought to defend against the allegations and mitigate potential legal consequences. Dear friends, we have got legal defenses available. So if sudden death occurs in our hospitals or in our clinics or in the OT tables, you should not be panicked. First of all, when we see the patient died all of a sudden, we lose our sphincters. So don't do that. So you must be cool and calm, and you must follow the guidelines which I have told you. I think this was enough for this sudden death or unexpected. So remember one thing lastly, any patient whose diagnosis is not done and he has died within the 24 hours of the admission, postmortem or communication to the authorities is always necessary, and it is your duty. Thank you very much.
Thank you, sir, for a precise thing what are to be done in case of sudden and unexplained death. You will be continuing with the next lecture.
Yes.
Yeah, please. Sir.
Yeah. Am I audible? Hello?
Yes, sir, you're audible. You need to share the screen again.
Again, I do see. Hello?
Yes, sir. Sir, please click on this share screen button.
हे येतं
PowerPoint open करायचं.
झालं झालं
आता just play something.
झालं इथं आवाज येतोय तिकडं
हो येतो.
ओके right. So our next topic is, am I audible?
Yes, sir, you're audible.
Doctors and staff, FIR, CRPC, police station, and arrest. As I have already told you, that criminal law is applicable to all the individuals and the doctors, with no exception to it. As far as the medical practices concerned, patients and relatives are usually don't have to the police station. But nowadays, this scenario is also changing. In the last 2 decades, as doctor-patient relationship has deteriorated, the complaints against doctors have increased. So there are many chances that doctors may get arrested. So according to the provision of the Indian Penal Code, that is IPC 1860, any act of commission or omission is not crime unless it is accomplished by a guilt. Guilt mind, that is in law, it is called as mens rea. The act are not punishable only because it led to some mischievous results unless associated with the intention and mental attitude of the person. Most of the times, doctor's treatment is in good faith with the consent of the patient, and hence most of the provisions of IPC are not applicable to the doctors unless or until there is rashness or gross negligence. Now, what are the sections which are applicable to the medical professionals? There are so many rules and regulations. Dr. Pramod has already told there are so many laws, rules, and regulations which are applicable to the doctors and the hospitals and the staff members and the pharmaceuticals. However, there are certain IPC acts which are basically for the medical profession, such as Section 29 of IPC, that it deals with the documentation, 52 with the good faith, 90 with the related to consent, 176 failure to inform police whenever there is essentiality, 269 to 71 related to the spread of infectious diseases and disobedience of a quarantine rule, 272 to 273 related to adulteration of the food and drinks, 74 to 76, 276 related to adulteration of the drugs, 304, which is most important, which deals with the death by a negligent act. There are certain other sections also, such as 306 to 309, such as abatement of the suicide, 312 to 314 related to causing miscarriage, abortion, and hiding such facts, 315 and 16, it deals with the prevent of child being born alive or caused to die after the birth, 319, 330, 322 related to cause hurting, grievous hurt, loss of vision, loss of hearing, or disfigurement. There is 336 to 338 deals with the causing hurt by rash or negligent act. 340 to 342 is related to wrongful confinement. 491 is related to breach of contract, and 499 is related to the defamation. But most important sections pertaining to doctors are Section 304 and 304A of IPC. Now, what is this? There is a lot of discrepancy while applying these sections in case of the professional negligence by the doctors. Most of the times, police authorities register the case of professional negligence deaths under the Section 304 of IPC. According to this section, the offense is non-bailable. Non-bailable means the person has to be arrested at once. He will not get bail. It is not bailable. This causes a lot of hardship, bad reputation, and mental agony to the doctors. In fact, the police should register the cases of deaths due to medical negligence under Section 304A of IPC, in which the offense is bailable and the doctor can be released on bail. The judgment has been passed by Bombay High Court in Criminal Revision Application 282 of 1996, Dr. Mridula Deshpande versus State of Maharashtra. It was delivered on 20th of November 1998. The basic difference is that in section 304, there is intentional act of negligence, while 304 is the act which is never done with the intention to cause death. Usually, most of the time, or 100% time, any doctor will try to save the life of the patient, and he will not deliberately or intentionally cause harm to the patient so that patient should die. Now, what are the grievous hurts? In section 391 to 322 IPC are related to causing grievous hurt, for example, loss of limbs, loss of vision, loss of hearing or disfigurement, etc. Section 336 to 338 deals with the causing grievous hurt by rash or negligent act. For example, while giving IV fluid, suppose there is a leakage of fluid in surrounding tissue resulting in a spasm of vessels and subsequent necrosis of the limb, or a surgical procedure is done on eye, limb, face, etc. without adequate aseptic precautions resulting in local infection. This may lead to loss of eye, limb, or disfigurement of the face, or an unqualified doctor performing surgical procedure which results in permanent damage to the eye, limbs, or hearing, etc. What is the wrongful confinement? A patient cannot be detained on the grounds of non-payment of hospital charges. This may constitute and the offense of wrongful confinement under section 340 to 342 of IPC. Doctors can take advance or fee from the patient before starting the treatment. If a police officer is keeping the doctor in detention in case of bailable offense, he is liable for the offense of wrongful confinement under the sections of the IPC. Now, there are some of the definitions doctor must know. So what are these? Like, you must know what is FIR, you must know what is the crime or of offense, you must know what is summons, what is warrant. So let us summarize this. Crime or offense means any act of omission which is contrary to any law or statute for the time being in force. Now, what is the summons? You usually listen the word. Summons is the process of court asking the opposite party to appear and answer the allegation referred by the party who has brought the action. Now, what is warrant? Warrant means an order issued by the court or the magistrate or a competent judicial authority directing the police officer to make arrest, seize, or search, or to do any other work incidental on to administration of the justice. Now, what is a warrant case? It is related to an offense punishable with the death, life imprisonment, or imprisonment for more than 2 years. For example, if doctor helps a pregnant woman in getting rid of the child or to cause its death after its birth, that is warrant case. The cases other than warrant cases such as summons cases, if a doctor acts negligently by using infected syringe or instrument resulting in an infection of an to an uninfected patient, exemplifies a summons case. Now, what is the cognizable offense? These offenses are those in which police officer may arrest without warrant, which is according to the Schedule 1 of the Criminal Procedure Code, that is CRPC. Now, what is the non-cognizable offense, which is usually called as NC? When you go in the police station, it is called as NC. What is NC? It means are those which are in police officers cannot arrest without a warrant. For example, a doctor knowingly disobeying a quarantine rule is liable to be punished with imprisonment up to 6 months or fine. Now, what is bailable offense and non-bailable offense? This also you must know, because bailable offense means in which the bail can be granted by any law for the time being in force. In such cases, bail is a matter of right. In court, the court cannot refuse bail and the police has no right to keep the doctor in police custody. If any police officer puts a doctor in detention, in such cases, he is liable for the offense of wrongful confinement under section 340 to 342 of IPC. Now, what is the bailable, non-bailable offense? Now, these are offenses are other than bailable or an offense in which bail cannot be granted. These are the serious offenses in which a person may be convicted and imprisoned for the term extending for more than 10 years. For example, offense under Transplantation of Human Organ Act 1994. Now, what are the presumptions of innocence? This is very important. Law presumes that a person is innocent till he is proved guilty, and the onus of the proof is on the prosecution. Means you have to defend only. The proof, the onus is lying on the prosecutions. So what is the mistake law? It means the ignorantia juris non excusat. It means ignorance of the law or mistake of the law. It means which is not excusable. Erroneous or wrong conclusion of law is not valid defense. For example, if a doctor carries out prenatal tests intent to abort a female fetus, cannot avoid prosecution by saying that I was unaware of any law which punishes such an act. What is mistake of fact? It is a situation where a person not intending to do harmful or unlawful act does so because a wrong conclusion or understanding of the fact. The guilty mind was never there while doing this act. So the person may not res judicata. This doctor law means the things have been decided. According to this principle, once the case is completed between the two parties, it cannot be tried again between the same parties. Suppose a patient sues hospital for any wrongdoing or damages or malpractices, and then the things decided, then he cannot subsequently sue the doctor again separately for the same negligence. Now, what is res ispa loquitur? Is a situation of gross negligence or rashness. The things are so obvious that it speaks for themselves. Most of the time, there are no need of proof of negligence in such cases. Common examples include giving blood transfusion to a wrong patient, or operating on a wrong side of the body, or operating a wrong patient. Now, what is the consent in criminal law? Now, this consent, about the consent, Dr. Ajay Mane is going to deal with. So I'm not going to go into the detail of it. Now, what is the criminal liability? A person who commits wrongful act shall be liable for it. The crimes are public wrongs, and aim for the criminal proceedings is to punish the wrongdoer. The law imposes liability on him who fails to perform the duty. The wrongful act may be it is intentional or willful wrong. This usually does not apply to the medical practices, as no doctor has, that I have already told you, that no doctor has intention to cause harm to any of his patients. And secondly, the negligent act. The doctor fails to take a proper care, proper precautions, or just indifferent for the consequences of this act, or the lack of skill proportional to the risk of undertaken also amounts to negligence. For example, I am not a surgeon, and if I do surgery and if something goes wrong, it will amount to the negligence. And wrongs of strict liability, these are created by some special statutes like Transplantations of Human Organs Act 1994. Now, there are certain situations where doctor has to inform the police in some circumstances. So what are these? These are: police must be informed in cases of suspected homicide, in cases of suicidal deaths, in case of unknown and unconscious patients, in case of death on operation table, suspected unnatural deaths, sudden, unexpected, violent and unexplained deaths, instant deaths after treatment or reactions of the medicines, and married lady dying within 7 years of the marriage. It's advisable to inform police in following circumstances. undiagnosed death within 24 hours of the admission, or especially if there is any suspicion. Secondly, any case of poisoning, you must inform police. Any case of accidental death, then the case of hospital deaths, then in the case of accident not related to medical management like fall from the staircase, etc., though there is no legal obligation on doctor, it is advisable to inform the police. Then unexpected or rare complications may sometimes occur. That is, a child may vomit, aspirate the content and may die. This is very unpredictable, and it is not obligatory on the part of the doctor to inform such tests. But it is better if you inform the police instead of what are the broad dead cases? In such cases, if the cause of the death is apparent, then there is no reasonable grounds to suspect some medical legal complication, then it is not necessary to inform the police. But it is advisable to suggest post-mortem in some of the circumstances, like whenever death is sudden or unexpected or unexplained. When there is accidental death, which may be on roadside, domestic or industrial. When there is a death is needed for insurance claim or as a help of to arrive final diagnosis. In some of the case of poisoning also, you must inform the police, and information of the police shall preferably in writing, and the written acknowledgement should be obtained. If the information is telephonic, then one must note down name, buckle number, and designation of the police of that particular police station. Now, I want to just tell you, we are talking about the can a doctor be arrested or can a staff be arrested from the hospitals? Yes, doctors have no immunity against arrest, as they are like any other Indian citizen. For the various criminal acts as per the provisions of the IPC or CPC of India, illegal organ trading, unlawful sex determination, etc., are non-bailable offences. Remember this. But the question is whether doctor will be arrested for alleged medical negligence during a day-to-day care of the patient, or unexplained hospital deaths like SIDS, like post-operative complication or failure of the operation, or for not attending or refusing a patient who becomes serious or dies, or not attending a case of roadside accident. Recently, the chairman of the hospital was arrested for not complying with the Supreme Court directives in a roadside accident. In this particular case, the patient died while being shifted to another hospital. The Supreme Court directives in the writ petition number 270 of 1988, in a roadside accident includes the medical aid should be instantaneous. It is the duty of the registered medical practitioner to attend the injured and render medical aid treatment without waiting for the procedural formalities unless injured person or a guardian. The effort to save the person and preserve the life should be the top priority of the doctor, and not only the doctor but also the police officer or any other citizen who happens to notice such an accident. You must be reading the newspaper. The last week I read in the newspaper, there's in Aurangabad near somewhere, the accident happened, and one guy fell from the two-wheeler and he had a serious injury, and people were shooting. He was shouting for and he was crying for the help, but no one gave him the help, and he was lying in that situation for 45 minutes and died subsequently. So this is the duty of the other citizens also to give the medical aid to that particular person. The professional obligations of protecting life extend to the every doctor, whether at government hospital or otherwise. The obligation being total, absolute, and paramount, no statutory or procedural formalities can interfere in discharging these duties. Whenever better or specific assistance is required, it is the duty of the treating doctor to see that the patient reaches the proper expert as early as possible. Now, what are the non-compliance of these directives? This may invite the prosecutions and the provision of Motor Vehicle Act or IPC 7. Suppose if a FIR is lodged by a patient his better approach is cases where he feel that patients or relatives may create nuisance. He has to follow following guidelines. He has to follow this, that the doctor should lodge a FIR that a particular incident has happened in my hospital. Secondly, he should say that a crisis management committee may be formed at each taluka or district level. The committee shall include doctor, social worker, legal personalities, politicians, press reporters, etc. The committee members may meet the police officer and request them for the complete investigations of the incidents and to avoid prosecution till the guilt is proved. The committee can also request the press reporters not to give unnecessary publicity to such cases. In the government of Kerala, according to that GR number, has issued the following instruction: if there are any cases of criminal negligence against the private practitioners or doctors or private hospitals, according to this GR, the investigating deputy superintendent of the police shall refer the case to a panel of superintendent of police, commissioner of police, district medical officer, or principal of medical college. Still, if the view is different, then the opinion of an apex body consisting director of health services and expert in that particular specialty may be taken. The affected doctor is also free to approach the apex body with his appeals. Now, if suppose medical person or a doctor gets arrested, so what does he have any rights? So what are the legal rights of an arrested person? These are not for the doctors. These rights are also for any person who is getting arrested. The arrested person shall be communicated with a particular offense and the ground for the arrest. If the offense is bailable, the person should be informed and the arrange for the bail may be made. If the police officer refuses to release such person on bail, he will be liable for damages for wrongful confinement. Sometimes a police officer may register an offense under section 304 of IPC instead of 304A in order to detain the accused doctor. In such cases, officer may have to face serious consequences. The person shall not subject to more restraint than necessary to prevent his escape. If there are any offensive weapons belonging to the arrested person, these weapons may be seized. The arrested person must be produced before magistrate having jurisdiction in that case. Remember this: no police officer shall detain in custody an arrested person for more than 24 hours unless order from a magistrate is obtained. Now you must know the procedure for the bails. So if suppose you come to know that there is a case or a FIR means a first information report is filed against you. So you have got the choice to go ahead with the anticipatory bail. What is the anticipatory bail? It means it is an order to avoid frivolous accusation. There is provision for anticipatory bail. This may be granted as a protection in offences which are non-bailable. In direction, it is direction to release applicant on bail. Means the court will give the order to the police to free the person or release the person on bail if there is an arrest. Once granted, it remains in force. Bail once granted, it remains in force. Now, what are the prerequisites for the anticipatory bail? Number one is there must be reasonable apprehension of arrest. And number two is the alleged offense must be non-bailable. And thirdly, the registration of FIR is not necessary. Merely you are afraid about something that you may face the FIR or you may face the consequences. You cannot approach the court for anticipatory bail because unless FIR is registered, you cannot anticipatory bail. Now, what is the procedure for bail? the accused person is required to execute his personal bond at the police station with or without surety. This surety may be close relative or a friend or a neighbor who is required to undertake to pay the said amount in case of absconding the accused person. Now, what are this last slide I'm telling you? What is the do's and don'ts whenever you you are doing practice and you are facing such situations? There are some do's and some don'ts. So what are those? Firstly, inform police whenever necessary. Usually what happens, we are seeing the welfare of the patients, we are worried about the patients, what the patient will think about us, and we doctors will be in trouble if we do not inform the police whenever it is necessary. So always remember, inform police whenever necessary. Secondly, extend all possible cooperation to the police. Thirdly, furnish copies of medical records to the police, court, or relatives whenever demanded. See, most of the times, what happens is doctor refuse to give these our medical records or some of the things. But you must be free enough, because it is a right of the whenever it required of the court or the police to demand for that. And for that matter, even patient can also demand his medical record. So you must give that. A consent of the patient may be taken while providing information to the police. The following legal procedures or provisions. What are the? You must always follow the legal procedures or the provisions. Now, have a valid informed consent of the treatment. Whenever we are doing any procedure, for example, surgery, for any other minor surgeries, or for that matter, any other type of treatment, you must take a valid informed consent. Inform means you must inform the implications of the treatment and acquire the written complaint. Next is preserve the documents. Here we lack what I feel. Most of the time, doctors, they are very much negligent about maintaining the records. They are very much lazy in writing the notes, in writing records, in writing the documents. So you must always preserve the documents, records, especially in the medical legal cases, controversial cases, or complicated cases. Insist for post-mortem examination if the cause of the death cannot be ascertained by you. So this is always important, because I have seen cases where many a times after 6 months patient relative will come and say, why you have not demanded post-mortem? We are doubting that there was a poisoning. Even a nearest relative may demand this. So always insist for post-mortem examination if the cause of death cannot be ascertained. Involve medical associations, medical legal cells, voluntary organization whenever legal problem arises. Consult your lawyer before giving any reply. If anybody has demanded you any questions, you always consult your lawyer, and before giving any reply, just check with it. Don't become panic. This is most important. As I had told you, whenever some mishap happens, we become very much panic, and we lose our sphincters and we lose our patience. So don't do that. Don't become panic. So don't manipulate or tamper with the documents. This will also, if you do it, you will be in very much trouble. So don't do this. Don't manipulate or tamper with the documents. Don't do unlawful or unethical acts. This is most important. As a doctors, we must do all lawful activities and we must practice ethically. Don't issue false or bogus certificates, or for that matter, backdated certificates. When the time will come about I will talk about the certificates and how I faced a police inquiry against me 20 years back. The certificate was issued on request is no defense. And so then don't neglect the treatment while completing legal formality, especially in serious or emergency situations. I think that is more than enough. And I told you about what you have to do when there is an arrest in case of the deaths, or when a doctor is liable to be arrested, or when a staff is likely to be arrested. So at that situation, any FIR is filed against you. So what are the criminal procedures? I have already told you. Police station. I have told you about all the legal defenses such as bails, anticipatory bails, non-bailable warrants, and all that I have explained to you. Thank you very much. Thank you for patiently listening.
Thank you, Iqbal sir, for an comprehensive explanation. What are the things to be done and what we should take care in case of any legal complications or legal emergencies. Thank you very much. The next speaker in line is Dr. Ajay Mane. He is currently Vice President of Foxy. He is medical legal expert and he delivers lecture at various state and national level conferences in IMA, in Foxy, and all other medical associations. He is also a medical legal expert, which is helping our colleagues in cases of medical legal issues. And he will be speaking back to back on the documentation at every step. If you don't know, you can be in trouble. And lastly, he will be speaking upon the consent. Over to you, Dr. Ajamani sir.
Yeah, thank you, respected Pramod Lonikar sir, and thank you, Iqbal Minne sir, for clearing so many doubts. So both of you have made my job very easy because few of the slides can be skipped due to your lectures. So the concepts are clear, and I'll be speaking firstly on consent and second on the documentation as Pramod sir said. Thank you very much. I'll share my screen. So this is a consent. Fine. So the first topic is consent. Basically, this is my small introduction. I'm a MBBS DJO, ND, FIC, OGA, FIH, Government of India, PGDHM, MBHR, BD, SELS, CC, BDM, and LLB. Vice President Foxy, State Representative AMOX 2426, member NIMC, medical legal consultant since 20 years, and only helping doctors. Not a single patient is helped by me. I am very much helpful to our fraternity only. So I am working for the doctors only. Okay. So following the posts I run. So I'll skip few of the slides because Minne sir has spoken very good on few topics. Pramod sir has spoken. So we'll be speaking medical legals. We'll skip this. These are the all the things. Okay. On a lighter note, to ease the tension which the medical legal word has created between you and me. So on a lighter note, what are the tips to avoid litigations in the medical practice? We all are at the gunpoint of the patients and the laws. So what is the practice we should do? Our safety first. How? There are 5 options. Okay. The first option, do not become a doctor, which we missed. Fine. So what is the second option? Though you become a doctor, don't practice. Do plotting, do construction work, do have a production factory or something like that only. Take it on a lighter note. Okay. Option number 3. If you want to do practice, select some non-surgical lines. Means only OPD and go back home at 5 o'clock and don't be panic or don't work in night and emergency calls. Fine. Then option number 4. Even if you have specialized in some surgical lines, do not do surgery. Means I'm a gynecologist, basically. Pramod Lonikar sir is a radiologist. Minne sir is a radiologist. Some is a surgeon. Somebody is a ophthalmologist. So you need to have a surgical branches, but become a medical gynecologist or a non-cutting surgeon or a ghost surgeon may come and operate in your hospital and you may pretend that you have done that. But mind it, in the ghost surgeon cases, the liability lies with you, not with that ghost surgeon. Okay. Because there is no name of that surgeon. There is a your name and being a owner of a hospital, you have vicarious liability, though somebody operates in your hospital. So don't think that somebody, Ajay Mane has operated in my hospital, so I'm free of allegation. No, you are liable for the punishment and the allegations, as it is a vicarious liability as a owner of the hospital. So don't relax. So you are under tension. And the option 5 for the surgeons, do surgery and strictly follow the basic rules, guidelines, and the protocols. The protocols are there. See, basically, our Foxy has given protocols, the FIGO has given protocols, WHO has given protocols, IMA has given good national protocols, Government of India gives all protocols. And if you follow these protocols, you are safe. Unless and until you do a gross mistake, you are safe if you follow the protocols. Though the patient is cannot be saved, the patient is succumbed, patient went to death, or whatever, but you have done the proper things at proper time by the protocols, you are saved in the court of law. That is damn sure. And take my words. Okay. So go by protocols, you are safe. Don't worry, don't be panic. Otherwise, these are the consequences. Okay. Fine. So the topic is consent, no? So though this is a basically agreement, as Minnesar said. Every promise and promises forming the consideration of each other is agreement. When agreement is enforceable by law, it becomes a contract, and consent is a contract. But in civil matters, the contract is to be registered, then and then only it is a valid. But in consent part, it is not like that. If a consent is signed by two parties, who are the two parties? One is patient and one is doctor. Both parties signs, it becomes a permanent contract. There is no need to register it. So it becomes a contract between the patient and the doctors. So all the laws for the contract and the everything is applicable, as Lunikar sir explained in first lecture. Okay. Indian Contract Act 1872 section 13 is applicable. Okay. When two or more persons agree upon the same things in the same sense. So consent, voluntary agreement, compliance or permission without compulsion, where legal validity of it is dependent on it being given after understanding clearly what it is for and the risk involved. Means what? Everything must be explained by either the doctor or the counselor to the patient and the relatives. See, this is the condition. This needs to be done. What is the alternative treatment modalities? And if not done, what will be the consequences? If done, what will be the consequences and the possibilities during the procedure? Means death can be there. It is not to be told. Okay, remote possibilities cannot be told. Only nearby, only infection can be there. The wound infection can be there. Likewise. Okay. Supreme Court in Jan 2008. Samira Kohli versus Dr. Prabha Manchanda. Justice Agarwal, Justice Navlikar, and Justice Ravindran were the judges. And this is the basic case where the word consent is being highlighted and got the importance. What is Prabha Manchanda and Samira Kohli case? I won't go into the detail. So, additional procedure done without patient's consent, and that too not in emergency situation was the case. If the patient is in emergency situation, if you want to save the life of the patient, you can do whatever procedure you want in good faith. Okay, but that must be justifiable, and the onus of proving the emergency lies on you. Means if court asks, what was the emergency, doctor? Explain me. You must explain that it was a life-threatening condition and you have done whatever you have done is in good faith. If court is satisfied, then it is okay for you. If that was not a life-threatening condition, like this in Prabha Manchanda case, patient was taken in the operation theater for a diagnostic laparoscopy. Okay, and they found something there, and they went for the total hysterectomy with the permission of her mother because patient was under anesthesia. So court said ki it was not a life-threatening condition. You should have come out of the operation theater. The patient should have come out of the anesthesia. Then she must have been explained all the things, then advised all the things, and second time she must have been taken in the operation theater and done the hysterectomy. That was the proper thing. But here, what did they did? They took the consent for the diagnostic laparoscopy and they did it a therapeutic laparoscopy. That was the wrong thing. Okay, without emergency situation, you cannot change the mode of action or plan of action without the consent or with the consent. Okay, so this is the detail of the Samira code. So, second reference. Mr. C. Jayapal Reddy versus Yashoda Group of Hospitals, Padmini Vellore and others. In Consumer Code 54 by 13, in Honorable Justice Malik and Justice Kandikar. What they said, they have given a word in the result that consent is not a mere piece of paper on which the patient and his relatives must sign. But consent should be considered as a proof of communication and counseling to the patient and the relatives. So consent is a proof of communication. Why we need a proof? Because the allegations are there that patient said कि no, हमको तो डॉक्टर साहब ने बताया ही नहीं है. So डॉक्टर साहब ने हमको तो अंधेरे में रखा, उन्होंने तो कुछ किया ही नहीं, उन्होंने तो ऐसे ही लिख गए कि 5 मिनट का काम है, and they brought the patient dead out of the OT. So we need to prove ourselves that we were into the good faith of the patients. We have explained everything and we have done the things. And what is the proof? The consent is the proof. Okay, fine. So consent is a voluntary agreement or the permission to do or allow something. Here, any procedure or examination too. Examination needs consent. Okay, but in OPD, it is implied consent. What is implied consent? It is taken for granted that patient is coming to your OPD and the patient has given you the permission to examine. Okay. Any patient who is about 12 years of age can give the permission of examination. Okay. Examination, I am saying. And the procedure, the consent, any procedure consent is given only and only by adult. If the patient is minor, then the consent must be taken by the doctor of his or her parents or the local guardian. Okay, not the legal guardian. Okay, okay. The first, so the types of consent are 4: implied, express, informed, and unanimous. So what is implied consent? Controversial form of consent. Why? Because it is a verbal consent. It is not a verbal consent. It is taken for granted consent that patient is coming to OPD or you are going for a home visit, that patient is supposed to be examined by you and it is granted. That is implied consent. Okay. Now, second part is express consent. It is clearly and unmistakably stated that may be given in writing. All consents can be given in verbal form. There are only 3 things where we need a writing, where PCPNDT, second is MTP, and third one is organ transfer. Okay, these are the 3 things where we need compulsorily in writing. But all other consents can be taken orally. But why we are taking it in, written format? Because patient may turn out anytime as a hostile. They may ali कि नहीं डॉक्टर माने ने हमको बोला ही नहीं, हमारा consent लिया ही नहीं. So how could a Mane prove that he has taken the permission of the patient or consent of the patient? So we need it in a written form. So I have expressed the things and taken the consent. That is express. And what is informed consent? Every part of the operation or the procedure is informed to the patient. Okay. Before sonography also we need a consent. That's why this is informed consent. We inform each and everything, positive as well as negative things, all the consequences if not done, what will happen, and what are the other modalities also. That also we need to inform them. Agar operation nahi karna chahta hai patient, so what can be the medical line of treatment, uske consequences kya ho sakte hain. Okay, तो इतना पूरा रामायण बताने की जरूरत नहीं. In short points we can explain that. So either a counselor may do that, or your assistant may do that, or you yourself can do that. So that is the informed consent. Okay. Or unanimous consent, it is a general consent given by the group of people, by association, IMA, FOXY, or all the. Okay. What are the criteria for the consent? The consent should be free, voluntary, clear, intelligent, informed, direct, and personal. Means kya? You should explain each and every corner of the procedure, and then only it is valid. Okay. And what are the negative parts? There should be no fraud. Means you should not give the false fascination or false picture of the procedure. Then it is becomes fraud. Undue influence. नहीं आपने अगर ये नहीं किया तो ये हो जाएगा, वो हो जाएगा. This is undue influence. Misinterpretation of the facts. अरे ये कर लो सो ऑपरेशन आपका तो खत्म ही कर दूंगा डिसीज में। सो दिस इज मिस इंटरप्रिटेशन। कंपल्सन करना ही पड़ेगा, क्या मतलब नहीं तो तुम्हारी जान जा सकती है, थ्रेट ऑफ फिजिकल इंजरी, डेथ, ये ऐसा बोल के जो कंसेंट लेते हैं, दैट बिकम्स अ नॉन वैलिड कंसेंट। फाइन, ओके। So, what are the principles of consent? Listen to the patient. What patient is explaining, listen to them. Okay, this is the complaint of patient. This is the information patient wanted from you. Explain. Discuss with the patient. Share with the patient what you are going to do, and respect patient decision. If you say कि okay, it is mandatory to do the operation, and patient says no, doctor, I don't want to do the operation, then अच्छा लिया साला मैं जब से explain कर रहा हूँ तुम सुन ही नहीं रहे. Don't do that. Respect the patient decision. देख भैया नहीं करनी है मत कर. This will be the consequences. I have told you, I have explained you. This will be the consequences. शांति के साथ में उसके सामने पेपर कीजिए, उसका सिग्नेचर लीजिए उसके ऊपर, and let him go. We are not there to have a compulsory treatment to the patient. We are there to explain them. If they wanted, you can proceed for the treatment. If they don't want to take the treatment, माफ कर दो, नमस्ते, निकलो. ठीक है. So doctor should explain patient's condition, which investigations are to be done, treatment, potential benefits, risk, burden of the side effects. Okay, and it includes option to have no treatment. अगर patient से नहीं चाहिए, okay, मैं नहीं चाहिए जाओ, basically. ठीक है. अच्छा, उसमें क्या क्या बताना है मैंने आपको बता दिया पूरा, इसमें क्या क्या कर सकते हैं. ठीक है. But there is no need to explain remote or theoretical risk involved. इसमें तो टेबल डेथ हो जाएगी ऐसा बोलने के बाद कौन सा पेशेंट ऑपरेशन के लिए तैयार हो जाए, है ना. तो वो करना नहीं है. जस्ट जो रिमोट पॉसिबिलिटीज है, वेरी रेयर पॉसिबिलिटीज, डोंट एम्फसाइज दे. जो नियर वाली पॉसिबिलिटीज वो बता दो. ओके. अब इसके स्कोप क्या है, मतलब हाउ it is a becoming a legal concept. Okay, so there are two main points: age of the signing authorities. One from doctor is already a doctor is an adult, basically the patient, the age of maturity. And what is the age of maturity by Indian Majority Act 1875? That a person who has completed 18 years of the age, completed, not started. Okay, 17 completed and 18 started, so he or she is not a major or an adult. Okay, it becomes a minor. They are not major. So 18 completed, that is the age where he or she can sign voluntarily on there. Okay, fine. In a sound mind, uh, he or she should not be in a any psychiatric condition, or under any influence of any drug, or under influence of alcohol, or under influence of comatose condition with after accidents also. That is also not a valid condition. That is a sound mind and sound body. Okay. Okay. If patient comes in a labor pain or a severe agony, oh, बहुत ज़्यादा दर्द हो रहा है, doctor, that consent is not valid. So what to do? In that situation, you can take consent of the near relative, saying that they have given in a good faith. There is a section for that. Okay. Okay, fine. Then who should sign the consent? One patient, one doctor, and one witness or two witnesses. One witness from doctor side, one witness from patient side. Why this witness is needed? Okay. Why this witness is needed? Witness says that the signature of the patient is done in front of me. That's all. That is the role of witness. The witness is nowhere related with the treatment, nowhere related with the consequences or other things. The witness is there to say that this signature is done in front of me. That's all. That is the role of witness. So we need two witness, one from patient side, one from doctor side, because the patient may say, no, no, ये तो इन्होंने forgery की है मेरे साथ में, मुझे तो कुछ बताया नहीं, इन्होंने दिल से ही किया है. दैट में हैपन, है ना. तो वो अगर नहीं कर सकते हैं तो उसमें वैसा होना चाहिए. फाइन. सो हाँ, वेरियस प्रोविजंस. ओके. आईपीसी 87 इंडिविजुअल पर्संस गिव वॉलंटरी कंसेंट, मैंने जो बताया पूरा. आईपीसी 88 कंसेंट गिवन बाय द रिलेटिव्स इन गुड फेथ. अभी जो बताया मैंने, पेशेंट इज नॉट इन कंडीशन टू गिव वैलिड कंसेंट, सो in that situation you can take a relative's consent in good faith. That is section 88. And section 89 says the consent of examination can be given above 12 years. I have already told. So consent in gynecology, being a gynecologist, I'll be emphasizing more on this topic, but the it is applicable to every surgical branch or a non-surgical branch also. A medical patient who is getting admitted in ICU also needs a detailed explanation about the procedures, the admission procedures, the medications given to him. Because yesterday only I have seen one patient who succumbed, and the report came 2 days back with the resistance to the antibiotic, and the antibiotic has not been changed by the doctor. So it is a negligence on the part of doctor. Okay, if you are attaching the sensitivity and the test and all the things with the papers, you should do proper thing, no? So I'm just telling you for an example. So it is a so pelvic examination. Pelvic examination, if the patient comes to your OPD, then it is a verbal consent. Okay. Breast examination also verbal consent, consent of unexpected pathology. So you should explain all the things. Okay. Consent in obstetrics. If the patient is in pain-free, then only you can. Say ki patient is coming for the labor, she's in active labor, so you cannot take the consent. So consent can be taken beforehand, maybe 7 days prior, 15 days prior. On the last ANC day, the patient's consent can be taken. Or say for an example, it is an interval appendicectomy. The consent is taken 1 day prior. Okay, come tomorrow, and the patient had a appendicitis again attack that same night, and tomorrow morning or the same night he get admitted. कि, "अरे, मुझे ये हो रहा है, ये हो रहा है." So with the help of that previous consent and with the relatives consent under 88, you can proceed for the appendicectomy or whatever the proper things. Okay. So this is in good faith. If the patient says that I don't want any treatment from you, or say for an example, a cesarean section is needed due to the fetal condition or the maternal condition, CPT is there, baby is not coming, delayed second stage, and the patient is not giving the consent. So the negative consent is to be taken. True for other branches also. What is the negative consent? You should explain everything and say that the patient is not ready. And what can be the consequences are explained to the patients, and the patient will be responsible for that. That should be signed by both doctor and the patient. Okay. Another situation I'll tell you. Patient consent पे साइन नहीं दे रहा, पेशेंट नेगेटिव कंसेंट भी साइन नहीं दे रहा, वो बोलता नहीं मैं जाऊंगा भी नहीं आपके हॉस्पिटल से और आपको साइन भी नहीं दूंगा, आपको क्या करना है. व्हाट यू कैन डिटेन भी नहीं कर सकते उसको, रिटेन भी नहीं कर सकते उसको, हकल के भी नहीं दे सकते. अभी तो बोला सुप्रीम कोर्ट ने बोला है कि लाइफ थ्रेटनिंग कंडीशन है, एगोनी है, पेशेंट का लेवल में, उसमें नहीं कर सकते. क्या करेंगे उसको? उस वक्त यू कैन टेक अ नियर पेशेंट्स रिलेटिव्स, उसके बाजू में जो पेशेंट है या तो अदर पेशेंट्स हु आर प्रेजेंट इन द विसिनिटी और इन द हॉस्पिटल, कि ये जो कुछ वाकया हुआ, वट एवर इज हैपनिंग was in front of us, and you can take the consent from that relatives. Or else there is a better way. You can have a CCTV camera with a audio visual recording. That is a must nowadays, because the paperwork is to be done, that is mandatory, but in many cases the time is not permitting to do the paperwork. At that time you can produce the recording of the CCTV camera as well as the recording of the audio visual in court of law, and court accepts that, and that is a valid consent, or the counseling you have given to the patient, court accepts that. Because patient say, अरे कागज तो है ही नहीं, डॉक्टर ने हमको एक्सप्लेन नहीं किया था तब, ऐसा हुआ, you can produce that. Okay. So there are so many cases the court has accepted. हर बात पे डॉक्टर को मारती ही नहीं है, कोर्ट अच्छे डिसीजन भी देते हैं बहुत बार, तो दे एक्सेप्ट आल्सो गुड थिंग्स. सो थैंक यू फॉर दैट. कंसर्न इन ऑब्स्टेट्रिक्स एंड रेडियोलॉजी, तो ये तो इसके लिए लेना पड़ेगा. ओके. अनदर, एक पेशेंट है जिसका ऑपरेशन करना है आपको, फाइन. उसके लिए कौन सी कंसेंट लगेगी? एक तो ऑपरेशन की कंसेंट लगेगी, दूसरी बात एनेस्थीसिया की कंसेंट अलग से लगेगी. एवरी टाइम यू नीड अ सेपरेट कंसेंट फॉर एनेस्थीसिया. अरे मैंने तो उसको बोला था कि ऑपरेशन होने वाला है, उसमें तो एनेस्थीसिया कंसिडर्ड है, तो हमारे जो ब्लैंकेट कंसेंट थी प्रीवियसली, आई हैव सीन 25 इयर्स बैक और 20 इयर्स बैक आल्सो, कुछ हॉस्पिटल में आजकल भी देखा है मैंने ब्लैंकेट कंसेंट. व्हाट इज अ ब्लैंकेट कंसेंट? ब्लैंकेट कंसेंट, मुझे डॉक्टर ने जो भी बोला है, जो भी प्रोसीजर है, जो भी एनेस्थीसिया के अंडर करेंगे, आई एम एक्सेप्टिंग दैट कंडीशन. दिस इज ब्लैंकेट कंसेंट. No, it is not acceptable in the court of law. Blanket consent is not at all acceptable. So what is consent? अब इसमें क्या हर बार लिखते बैठेंगे? No, you can have a printed format. One is information sheet, second is the signature sheet, where you can have blank spaces for one name of the patient, age of the patient, address of the patient, then diagnosis of the patient, procedure you are going to do on the patient's name of the surgeon, name of the anesthesiologist, date, time, whatever, and then consent and signature of both of them and witnesses. That can be done, no? Every time you need not write down कि from A to Z और उसका तो time तो 2-2 घंटे तो consent में ही लग जाएंगे patient का operation करते हैं. So you can have printed format, but give the spaces and you should write it with the pen. और अगर कंप्यूटराइज है तो कंप्यूटर प्रिंट निकाल के भी उसके ऊपर यू कैन हैव दैट स्पेसिफिक दैट पेज इज कनेक्टेड विद द पेशेंट ओनली. दूसरा पेशेंट है तो उसका दूसरा पेज आएगा. ये ब्लैंकेट कंसेंट नहीं चले. ठीक है. तो ब्लड ट्रांसफ्यूजन ऑल प्रोसीजर्स इफ प्लान इज टू डू इन द सेम सिटिंग. अगर दोस्त आप चीजें कर रहे हो कि सपोज आई मीन गायनिक फील्ड, सो आई विल टेल one example कि you are doing a cesarean section of G2 and in the same sitting you are going to perform the tubal ligation or the tubectomy. Then you need to have two points in the consent, that one is for cesarean section, second is for the tubectomy. Right? Okay. Likewise in surgery also, if you can do it. नहीं, मैंने तो खोला था तो मुझे दिखा अपेंडिक्स तो मैंने अपेंडिक्स भी उड़ा दिया. ऐसा नहीं चले. Okay? You cannot do that. If unless and until you have not taken permission for the appendectomy. वो पहले जमाने में चलता था, अरे मैं गए था तो अब क्या करूं, मैंने उड़ा दिया. ऐसा नहीं चले. फाइन. ओके. आईसीयू एनआईसीयू एडमिशंस एंड ऑल प्रोसीजर्स. आप उसको एडमिट कर रहे हैं, उसमें आप सेंट्रल लाइन डालने वाले हैं, सेंट्रल लाइन नहीं डालने वाले हैं, ट्रैकेस्टोमी करने वाले हैं. एवरीथिंग नीड्स टू बी इन्फॉर्म टू द पेशेंट एंड टेकन अ कंसेंट फॉर सेपरेटली. ओके. देन वार्ड प्रोसीजर्स है, उसमें आप उसका टैपिंग कर रहे हो, सपोज पेरिटोनियल फ्लूइड का टैपिंग कर रहे हो या तो प्लूरल फ्लूइड का टैपिंग कर रहे हो उसका, है ना, या तो एलपी कर रहे हो उसका आप उसमें. तो एवरीथिंग इज टू बी इन्फॉर्म एंड टेकन. रेफरिंग पेशेंट्स में क्या करेंगे, यू नीड टू गिव अ गुड लेटर टू द अदर हॉस्पिटल वेयर यू आर रेफरिंग द पेशेंट, आइदर फॉर द इन्वेस्टिगेशंस. अभी आप सब लोनिका सर के पास यू आर सेंडिंग अ पेशेंट फॉर सीटी स्कैन. ओके. यू शुड राइट डाउन द पेशेंट्स नेम, द डायग्नोसिस, desired investigations, and what is your tentative diagnosis, and send it to the proper on your letterhead, not on the printed form, on your letterhead with your stamp and signature. Then and then only it is a proper referring letter. Fine. If you are referring a patient to another doctor, तो उसमें क्या आएगा, उसमें पूरा पेशेंट्स का दौरा आएगा, उसमें क्या क्या लिखा है, फिर उसका डायग्नोसिस क्या है, उसका ट्रीटमेंट क्या दिया आप लोगों ने, उसको क्यों रेफर कर रहे हैं वो भी लिखना है. बिकॉज इट इज रेफरिंग फॉर द हायर साइड ट्रीटमेंट और टर्शियरी केयर सेंटर ट्रीटमेंट. ही नीड्स अ फर्दर आईसीयू केयर व्हिच वी डोंट हैव. लाइकवाइज यू नीड टू मेंशन एवरीथिंग एंड then send the patient to the. Okay. Consent of training. If you are having a trainee with you, seeing at the time of patient procedure, then you need to take the consent of the patient that the trainee will be seeing the procedures and learning something. Okay. Consent for obtaining tissue samples, उसका भी लेना पड़ेगा. Publication, किसी पेशेंट का डेटा आप पब्लिश करते हो किसी कॉन्फ्रेंस में से, you should take a permission. एंड स्क्रीनिंग का भी आपको परमिशन लेना पड़ेगा. कंसेप्ट अंडरटेकिंग तो अभी आया कि इफ समथिंग गोज रॉन्ग आई विल बी रिस्पॉन्सिबल. सिंस दिस कोरोना काल वी हैव डेवलप दिस अंडरटेकिंग. ओके. सो दीज आर सम रिटर्न कंडीशंस. आपको कहाँ कहाँ लगेगा बेसिकली. सो दिस इज what summary. Okay. OPD, PSPV, per abdomen examination, all OPD examinations, refraction. Okay. इसके लिए implied और verbal on written if needed written. अब आप चश्मे का नंबर चेक करने जाते हैं, वहां डॉक्टर आपका साइन लेता है? नहीं लेता ना. You don't take. It is implied consent taken for content. आप जाएंगे वहां बैठेंगे, आपको लेंस लगाएंगे, नंबर देखेंगे, खत्म हो गए. That is implied consent taken for granted. Okay. पर अगर प्रोसीजर कुछ कर रहे हो तो उसमें कंपलसरी लगेगा. इसमें डिलीवरी है, इंस्ट्रूमेंटल डिलीवरी है, वेनी सेक्शन, देन आईसीडी डाल रहे हैं इसमें चेस्ट में टैप करने के लिए, सेंट्रल लाइन डाल रहे हैं, डायलिसिस है, माइनर प्रोसीजर्स, एनआईसीयू, आईसीयू एडमिशंस एंड प्रोसीजर्स. It requires a written informed consent. Okay. C-section and all operative procedures, written informed consents, and anesthesia separate consent, blood transfusion separate consent. Why? See, for blood transfusion you need a separate consent. Not every time. If you are giving 5 times 5 units, not every time you need a consent. You need a consent for first time only, and then give detail of every transfusion in the paper. तो उसको blood group क्या है, match किया है, cross किया है, उसका number क्या है, ये what every. But 5 steps or 5, I'll tell in documentation lecture that everything is to be written 5 times, because the number is different, the batch number is different, the bag number is different. Every time you need to have cross match with that bag sample, everything that you have to write it down. But the consent is only one for the blood transfer. Okay. Okay. MRP and emergency procedures or written consent, all surgical procedure, written consent, laparoscopy, diagnostic, therapeutic procedures, referring a patient, written consent. If you are referring patient, MTP, Form C, and now another one. Okay. Ultrasound, a pregnant woman, separate consent with Form S. Amniocentesis, amnioinfusion, BT, Korean villus biopsy, IOI, IVF, home pickup, genetic lab, permanently removal of any body part as a treatment part, special consent is needed. Because as Minne sir also said, and Lonikar sir also said that removing a part and removing a wrong part is a grievous injury. Okay. And that needs a very special punishment, and that is there in the law. Okay. Fine. So I don't want to repeat the things. Everything is given. For gynecologists, it is a website of our Foxy, www.foxy.org, where we have given a 30 procedures uniform consents. Anybody can take out the printout, print it on your letterhead and use it. So we have given free of cost. That is information first part and consent properly in a second. Okay. And if needed, I am there. It is a service to the doctors. You can contact me in any case. We can give either me or Minne sir or Lonika sir. We are there to help you, and it is a paid service basically. So you can give advice. You can give points to your lawyer, and the lawyer may present this to because we are doing since so many years. Every week at least, or 2 or 3 times a month, we are doing the things, and the doctors are free of allegations. And that will be a very helpful thing, because taking that case burden on you and treating the patient is very dangerous situation. This is my mobile number, 2 mobile numbers, and this is my mail ID. So you can mail me or call on this number. Fine. This is woman empowerment in Israel. She is carrying a gun for herself and for baby, but this is a woman empowerment in India. So this is Dr. Captain Dr. Deepashika Chetri. I salute the woman, because she is carrying a gun for the nation, Stato for the unit, and she is there at present in the China Glacier since 6 months. So this is a woman empowerment in India. So we need that. And whatever we have seen, we have given 2 अब्ज लोगों को हमने वैक्सीनेशन किया है. किन्होंने किया है? इन लोगों ने किया है. These are multi-purpose workers and the ASHA workers. They have gone to such place. See, इस जगह पे जाके उन्होंने टीकाकरण किया है. शी सिटिंग इन द कच्छ का रन. देखिए. सो दिस इज ड्राई एरिया, हस्बैंड एंड बेबी कैरिंग कैरियर, वैक्सीन कैरियर, एंड इन कंडीशंस में इन्होंने किया है. सो इन सबको अपना सैल्यूट बनता है बेसिकली. सो थैंक यू वेरी मच. सी, दिस इज द नॉन फ्लाइंग बर्ड्स. व्हेन दे कैन स्टे टुगेदर, व्हाई कांट वी? सो आप आपके कलीग के बारे में कुछ टेढ़ी मेढ़ी बात नहीं करेंगे. कोई पेशेंट आता है आपके पास, जो कोई अजय माने की तरफ से आया, मिन्ने सर के पास, मिन्ने सर ने बोला, अरे माने के पास से आया क्या, जिंदा आया साला. तो डोंट टॉक लाइक दैट. ओके. ये तो मैंने एक जस्ट एग्जांपल के तौर पे दिया है. वी डोंट डू दैट. मैं भी नहीं करता, मिन्ने सर भी नहीं करते, लोनिकर सर भी नहीं करते. आपने भी करना नहीं चाहिए. अगर आपको कोई ग्रॉस निग्लिजेंस गलत भी दिख रहा है उसमें, तो यू प्रोटेक्ट योर डॉक्टर्स. ओके. तो उसमें ऐसा. And lose talk, don't do lose talk, because anybody can have the situation where you need help of your colleagues. Fine. So thank you very much. The topic of consent ends here. We'll proceed with the topic of documentation. Fine. Pramod sir, shall I continue?
Sir, please.
Thank you very much. Okay, just a minute. Let me open the. the next topic is documentation. So consent is a part and parcel of documentation. So consent is equivalent to documentation? No. Only consent is not a documentation. Documentation comprises of very much documents which are involved in the patient treatment procedures. And what are the documents? Only paperwork is not a document. Okay. Your video recording is a document. Your audio recording is a document. Whatever the evidences are there, they are coming under the definition of documentation. Okay. So I'll skip few of the slides. Patient can do anything. Ivan James and whatever, because see the what is died on 20th June 2001 due to the negligence of Sujata Birla Hospital and Chawla. They can engrave it. Patient can do that. The journalists also cervical cancer से बचने के लिए टीकाकरण जरूरी. And what they have shown, cervical cancer, गर्दन का. So cervical cancer यहाँ पे इनको क्या expected है कि cervix, गर्भाशय का मुख जो है. एंड ये कुछ एडवोकेट्स के कारनामे है यूरोप में. उन्होंने आर यू विक्टिम ऑफ मेडिकल नेग्लिजेंस, वी आर देयर टू हेल्प. ओके. एंड इसमें उन्होंने क्या दिया है कि दे हैव गिवन दैट फॉर फ्री ऑफ द कॉन्फिडेंशियल. जस्ट अ मिनट, आई जस्ट अ मिनट प्लीज. हॅलो सर, माझं लेक्चर चालू आहे. Fine. So no win, no fees basis it is called as. Means what? They come to you, they instigate you कि अरे डॉक्टर पे केस कर देते हैं. Okay. And you say कि what will be your fees? It is free. If you get something as a compensation from doctors, give me 10% or 20%. If you don't get, if you lose the case, don't give me anything. So what patient think? अरे साला इसमें तो नुकसान कुछ नहीं है, देना कुछ भी नहीं है, अगर जीते तो देंगे, अब करने वाला कौन है, यही तो करेगा. तो okay, they'll say. So the cases are increasing. Why? Due to such kind of persons. And this is the mob violence we are facing day to day. I'll give you the, if it is, then yes. See, this is ICU basically. We are taking care, we have changed clothes, mask, everything. This is the doctor, and the patient is serious. That any doctor in this world is not thinking to have the patients become serious. Okay. They wanted to treat the patient, to the betterment of the patient and send the patient treated in condition. See the relatives, what they are doing. See, they can do anything. So they can do it in presence of police also. So this is a very serious condition we are facing day to day. Okay. And the legal people say that doctors are enjoying a lot. So this is the truth. Okay. So what is documentation? Everything is to be written or documented. Otherwise, it is considered as not done or not performed. Whatever there is there in the document is considered as done or performed. If you have done the resuscitation and if you have not mention it in the paper that you have done the resuscitation, then when the case is there in the court of law, it is considered that you have not done the things. Okay, so kindly write it down. Whatever you do, write it down. Okay, medical documentation, any form of the record documentation by clinician recorded in a professional capacity in relation to the provision of the patient's care may include written or electronic health records, audio, video, email, fax, WhatsApp. If you send the message of the follow-up schedule to the patient, it becomes a documentation. आपने पेशेंट को बुलाया 7 दिन के बाद में, आप सपोज एमटीपी का पेशेंट है, आपने उसको दे दिया, अबॉर्ट हो गया, उसने बोला, आपने बोला कि ओके कम आफ्टर 7 days, एंड पेशेंट didn't turn for 1 month and afterwards they came कि अरे मेरा तो इन्फेक्शन हो गया, मेरा ब्लीडिंग हो रहा है, यूं हो रहा है, त्यों हो रहा है. अगर कोई परफोर लैप्रोटोमी का पेशेंट है, आपने उसको 7वें दिन 8वें दिन स्टिचेस निकाल के घर पे भेज दिया और उसको बोला कि चलो 5 दिन के बाद में आके एक बार फिर से बताओ, पेशेंट डिडंट टर्न एंड 1 महीने के बाद में आया कि अरे तो इन्फेक्शन हो गया, मेरा वुंड गेपिंग हो गया. So in that condition, if you have given the proper schedule, if you have sent the email, or if you have given the schedule on the WhatsApp also, it becomes a documentation, and that is helpful to you. And if patient do not listen and they are at fault, it becomes a contributory negligence. What is the negligence? The doctor is at fault. He has not done the proper duty. That is a doctor's mistake. But the patient has not listened the doctor's instructions और द इंफॉर्मेशन गिवन कि ये करना है, ये करना है, उसके विपरीत उसने कुछ कर दिया. सो देन इट बिकम्स अ contributory negligence on the part of patients. Okay, and that is helpful to the doctors. Fine. So WhatsApp chat, images, charts, it becomes a documentation. Why it is needed? Because it is proof of communication. You are accountable for that. You need to keep the that. It is for record keeping. It is for insurance claim. It is a legislative requirement. If something goes wrong, court requires the documentation. And quality improvement. You need to review the record. कि चलो 3 महीने में क्या क्या केसेस हुए, इसमें हुआ ये मिसडायग्नोसिस है, so sorry, इसमें हम इम्प्रूव कर सकते हैं, यहाँ आपकी सर्विसेज इंप्रूव कर सकते हैं, यहाँ पेशेंट का ट्रीटमेंट इंप्रूव कर सकते हैं, यहाँ पे इंफ्रास्ट्रक्चर इंप्रूव कर सकते हैं. फॉर दैट यू नीड अ रिकॉर्ड और द डॉक्यूमेंटेशन. दैट इज अ क्वालिटी इंप्रूवमेंट, कंप्लायंस एंड रिसोर्स मैनेजमेंट. ओके, तो व्हाट आर द रिकॉर्ड कीपिंग? उसमें मैंने अभी बोला आपको कि मैनुअल भी हो सकता है, इलेक्ट्रॉनिक हो सकता है. तो व्हाट आर द एडवांटेज ऑफ इलेक्ट्रॉनिक्स? जगह कम लगेगी, लाइफ स्पेन ज्यादा रहेगा, क्योंकि यू नीड टू कीप रिकॉर्ड्स फॉर सो मेनी इयर्स. आई विल शो द स्लाइड्स, उसमें दिया है कितने साल का है. कुछ तो रिकॉर्ड, हमारा बर्थ रिकॉर्ड तो वी नीड टू कीप इट फॉर 21 years, सरोगेसी 25 years. सो वी नीड अनदर बिल्डिंग फॉर द रिकॉर्ड्स. सो अगर वो इलेक्ट्रॉनिक में टाइप में है, सो इट नीड्स अ वेरी लेस स्पेस. रिट्राइव ज्यादा कर सकते हैं, फटाफट कर सकते हैं, उसको जल्दी निकाल सकते हैं. ओके, सो हाउ टू डू इट? इट मस्ट बी कंसाइज, एक्यूरेट एंड ट्रू. सीधा सीधा होना चाहिए कि कंसाइज. उन्होंने तो लंबा चौड़ा रामायण लिखा, उतना ऐसा नहीं. पेशेंट केम एंड देन ही रिमूव्ड हिज चप्पल एंड केम इनटू द OPD and he started telling that in morning. No. What are the complaints? What is your diagnosis? That is a concise and accurate and true. You should not have a forgery or a false things written in that record. That is very problematic or troublesome to you. Okay, clear and legible. Chronological means what happens first, second, third, fourth, fifth. That is chronological. Current and confidential. It should not be revealed to anybody. Okay, as Minister said, if the police inspector legally needs any record, he or she have to give an application to you. Without written application, you should not give any document to the police. Though DYSP come, though SP come, though commissioner comes, you ask them politely, sir, it is a procedure legally, kindly give me a letter, and then only I'll give you the photocopies of the record. Don't give original papers to anybody. Anybody. In the court also, you need to produce the true copies and certified true copies with the number on the right upper side, 1, 2, 3, 4, 5, 60 pages paper, true copy. Original paper must be kept with you, because if you give the original paper and if it is misplaced, you are nowhere. So keep in mind that you should give every time a photocopy, not an original paper, to court, to police station, or if patient asks for that, you should give the photocopy of the paper. Only investigation reports, you should keep a photocopy with you and give them original records. Patient, not to the police station. Police station, only photocopy. Court, only photocopy. And for the want of seeing the papers, if judge asks, okay, produce the original paper, take the original paper, take the original register with you, show it to them and bring it back. Don't submit. Okay. And if they ask to submit, take a receipt from them. The original paper is submitted with this, and then to have the responsibility of the paper is their work. Okay. So it is a procedure. Consistent with guidelines and legislation, avoid abbreviations. Abbreviations, I'll give you an example. When I went to Mumbai for my post-graduation in 1998, that time, I'm from Aurangabad. No, so basically Aurangabad is considered as a very lay person or layman in point of Mumbai people. So the first day I went and saw the patient, SOPV. So I could not understand that. SOPV, what is the diagnosis? It is not given in any book of my obstetrics and gynecology. So I asked the CR, Deepa was the chief resident there. Deepa, what is this here? You don't know SOPV? You people from, okay, whatever the words. And something coming out per vagina. So why can't you write down the prolapse? So don't use abbreviations. Fine. Okay. Who should do it? Doctors, nurses, midwives, paramedical staff, other care providers, and patients. I'll tell you the importance of this. Doctors, okay, you are writing the notes. Nurses, I'll tell you my own incidents. In one of my hospitals where I was working as a director administration, there was a case of pediatric surgery done. The patient succumbed after a few hours and everything was done. The patient's paper was taken by the police. Police must give 72 hours to the hospital persons to complete the papers. That is the rule. That is the law. If police don't give you the time and they wanted to take the paper right at that moment and the paper is incomplete because you are busy with the resuscitation of the patient, so you are not writing the notes, you are resuscitating the patient, and police, if something goes wrong and police comes and no, abhi to hum paper leke jayenge, so what you are going to do, you are putting a slight line आफ्टर आपके आधे नोट्स हो गए, आधे नोट्स बाकी है आपके, हाँ, तो वहां पे एक जस्ट पुट अ लाइन and write down one sentence. This paper is incomplete. Police did not give me time to complete the paper. Sign, stamp, दे देना. उसका जेरोक्स निकल के आपके पास रखो, वो दे दो. वहां पे फिर जो कोर्ट में उसकी 12 बजेंगे तो वहां बजा ही देंगे. Because by law they should give you a proper time to complete the paper. So इसमें भी वैसे हुआ ये केस में, where I was administrator. तो उन्होंने नहीं दिया. So police took the patient. But in court, the judge asked, यहाँ पे तो आपके notes है ही नहीं. So means you have not done the resuscitation. Well, sir, with a humble request, you please see the nurse's injection chart. So he went on the paper. So whatever the page number 32, 33 or something, and he saw the injection chart where the nurses have given soda bicarb, adrenaline, whatnot, 1, 2, 3, 4, 5, 6, 7. And then we explained that, sir, the nurses are there to obey the orders of the doctors. They are not permitted to give injections on their own. Means the injections order was given by the doctors, means the resuscitation was done by the doctor and the nursing staff. But the police has not given time to complete the record. That's why it is a vacant. And court considered that. Court considered that कि nurses chart में लिखा हुआ है. That means doctor has done his duties and there is no negligence. तो उन्होंने डॉक्टर्स को उस केस में से बरी किया. So acquittal हुआ उसमें से. No conviction. So court considers. So this is the importance of everybody's work. So nurses की चार्ट की वजह से हमारा हॉस्पिटल बच गया एक दिन, जो डॉक्टर के नोट्स पूरे नहीं थे फिर भी. So everybody should do that. Fine. When कब करना चाहिए? As a chronological record. पेशेंट ओपीडी में आया, ओपीडी का रिकॉर्ड लगा उसके पीछे, वो इंडोर एडमिशन हुआ, एडमिशन का रिकॉर्ड लगा उसके पीछे, उसके राउंड से सवेरे शाम का एनेस्थीसिया कंसेंट है, उसको काउंसलिंग का कंसेंट है, किसी थर्ड पार्टी का आपको ओपिनियन लेना है, मे बी अ सर्जन और पेडियाट्रिक सर्जन और ऑन्को सर्जन और साइकेट्रिस्ट और फिजिशियन, उनका भी नोट्स उसमें आना चाहिए. देन यू टेक द पेशेंट टू द ऑपरेशन थिएटर फॉर द, उसकी कंसेंट आएगी, फिर उसका फॉलोअप आएगा, उसका सब होने के बाद में पेशेंट क्योर्ड, उसके बाद में उसका डिस्चार्ज कार्ड आएगा, डिस्चार्ज समरी आएगी उसकी, एंड देन द पेशेंट गोज ऑफ. दिस इज अ chronological way. Okay, it should be in the appropriate manner. And when at the time or as soon as it is a practicable, the action or event variance जो मैंने आपको अभी बता दिया. ठीक है. मॉनिटरिंग द डॉक्यूमेंटेशन, ऑडिट ऑफ द डॉक्यूमेंटेशन पॉलिसी एट रेगुलर इंटरवल, 3 महीने 6 महीने के बाद में आप ऑडिट करो पूरा कैसे चल रहा है, क्या चल रहा है. रिव्यू ऑफ स्टैंडर्ड एंड क्वालिटी, रिव्यू एविडेंस. ओके, अप्रूव्ड. हाई स्टैंडर्ड ऑफ कंटेंट, ये पूरा वी कैन स्किप दैट. अब देखिए व्हाट इज द डॉक्यूमेंट्स, क्या क्या रहेंगे. रूटीन डॉक्यूमेंट्स, ओपीडी पेपर, इंडोर पेपर, इन्वेस्टिगेशंस, ओपीडी रजिस्टर, इंडोर रजिस्टर. अभी तो एवरीथिंग इज इलेक्ट्रॉनिक nowadays, so you need to save those electronic records because it can be deleted or it can be, हो क्या वायरस वायरस अगर आ गए ना उसमें तो पूरा खत्म हो जाएगा. तो सो यू नीड टू कीप इट फॉर 2 places. तो एक तो सही रहेगा. ओके, इंडोर रजिस्टर, डिलीवरी रजिस्टर, ऑपरेशन थिएटर रजिस्टर, एमटीपी रजिस्टर, पीसीपी डिटेल रजिस्टर. ओके, autoclave register, it is very important that how many times you autoclave your instruments, how many times the circle is given, how much time is given, उसका record क्या रहेगा, उसकी जो strips है autoclave के strips. अब I have seen 2-3 times that they have given 2-3 black strips, but one strip is cut in 3 pieces and it is stuck in 3 places. So don't do that. ऐसा मत समझो कि सामने वाले कुछ समझता नहीं है. Judges are very clever. The opposite party advocates, they are also very clever, so they will object. So autoclave में you do it legitimately, you do it in proper protocol way, so you are out of fear. Fine. Autoclave register बहुत जरूरी. Fumigation register is important. Fumigation में you should have at least 3 times your report from the labs. Maybe at least once a year you should take a swab report from a government lab. And from where the 6 swabs are taken, one is floor, second is table, third is boils apparatus, fourth is wall, fifth is that light, and sixth the operation trolley, the instrument trolley. These are the 6 sites from where you take the swabs, send it to the lab, and उसका आप report रहेंगे आपके पास रहेगा. आप प्राइवेट लैब से कीजिए, दैट इज एक्सेप्टेबल, बट एटलीस्ट वंस अ ईयर यू शुड टेक वन रिपोर्ट फ्रॉम गवर्नमेंट मेडिकल कॉलेज रादर और गवर्नमेंट लैब, देन इट इज अ वैलिड, आपके पास उसका प्रूफ होना जरूरी है. ओके, दैट इज अ स्वैब रिपोर्ट. बायोमेडिकल वेस्ट रजिस्टर सर ने बताया आपको, जैसे कि कितनी बार दिया आपने बायोमेडिकल वेस्ट, उसका रिन्यूअल है. ओके ओके. एंड विजिट बुक. व्हाई विजिट बुक? बिकॉज द पर्सन्स हु आर इंस्पेक्टिंग और कमिंग टू योर कैंपस मस्ट बी टेकन केयर ऑफ. तो वहां पे रखना चाहिए कि हमारे पास आके गए, अरे हमारे तो आए नहीं, तुम्हारा 6 महीने से तुम्हारा इंस्पेक्शन हुआ नहीं. पीसीपी एनटीटी में तो 3 महीने को रिकॉर्ड इंस्पेक्शन होना चाहिए. आए थे, देखो ये उनका साइन है, या डॉक्टर माने आए थे उनका साइन है. तो ओके. केयर रजिस्टर, व्हाट इज केयर रजिस्टर? वी डोंट कीप केयर रजिस्टर. आई हैव सीन 99.99% ऑफ द हॉस्पिटल दे डोंट कीप केयर रजिस्टर. व्हाट इज केयर रजिस्टर? Care register is that register where you mention all the medications which you purchase for your use. Say for an example, मैंने MTP kit खरीदी की है. 100 MTP kit is with me. I have given 10 MTP kit to 10 patients. वो care register mention करो कि 100 purchased, 10 given to 1 2 3 4 5 6 7 8. उसमें तो नाम तो नहीं आएंगे. If it is MTP, it is MTP number 365/2024. ओके. एक बार रजिस्टर 3 में उसका एंट्री होने के बाद में एमटीपी का नाम कहीं भी नहीं आता. इट इज कॉन्फिडेंशियल. इफ यू राइट डाउन द नेम ऑफ अ एमटीपी पर्सन, इट इज अ ब्रीच ऑफ कॉन्फिडेंशियलिटी. आपको 1 साल की जेल है उसमें. पहले 1000 रुपए जुर्माना था. नाउअडेज इन अमेंडमेंट दे हैव गिवन दैट देयर इज अ प्रोविजन ऑफ 1 year imprisonment फॉर डिक्लेयरिंग द नेम. सो इट इज अ वेरी स्ट्रिंजेंट लॉ. फाइन. तो वो रिकॉर्ड, तो आपने 10 परचेस किए हैं, 3 इस्तेमाल किए हैं, 7 आपके स्टॉक में है. ये जो ब्यौरा रहेगा कोई भी मेडिसिन का, दिस इज गिवन इन केयर रजिस्टर. सो प्लीज मेंटेन, whenever the food and drug officer come to your hospital, he will ask that where is your care register. If it is not there, he will give you a notice. So it is a mandatory to keep the care register. स्टॉक रजिस्टर ऑल्सो मैंडेटरी, कंडेमनेशन रजिस्टर, आपने कितने इंस्ट्रूमेंट कंडेमनेशन में निकाले हैं, जो भी है, मीटिंग मिनट्स रजिस्टर है, ड्यूटी रोटेशन रजिस्टर है, नर्सिंग अटेंडेंस रजिस्टर है, इन एंड आउट रजिस्टर है। एक केस में तो मैं खुद बच गया, मैं 1 बजे बाहर गया था और 9 बजे हॉस्पिटल के अंदर आया रात में। तो मीनवाइल 4 साढ़े 4 बजे एक ऑपरेशन हो गया था, उन्होंने एलिगेशन किया था कि डॉक्टर माने वाज आल्सो देयर इन ऑपरेशन थिएटर, सो आई शोड द इन आउट रजिस्टर कि वो जज एक्सेप्टेड, क्या रे वो तो सिक्योरिटी गार्ड है, उसको क्या है, डॉक्टर माने बाहर गए उसने लिखा, डॉक्टर माने वापस आए उसने लिखा, सो नो फोर्जरी इज देयर। सो उनका जो एलिगेशन था इट वाज फॉल्स एलिगेशन, सो एक्विटल हुआ मेरा। So this is in and out register. ये छोटी छोटी चीजें है but it saves you so many times. Okay. Attendance register of all employees, all machines, routine servicing record. इसमें भी रखो कि आपका कोई वेंटिलेटर है, उसका आपने सर्विसिंग नहीं किया, वो बंद पड़ा हुआ है और पेशेंट कोई सकम हो जाता है तो that is a negligence on your part. एक ने तो जनरेटर का किया नहीं था, जनरेटर वाज एट द सर्विसिंग सेंटर, उसका लाइट गए ऑपरेशन के दौरान, उसका कॉम्प्लिकेशन हुआ, सो तो पेशेंट वन कि उसने वो रिकॉर्ड लाया कि जनरेटर वाज नॉट देयर, अल्टरनेट लाइट सोर्स नहीं था उनके, ऑल एनुअल मेंटेनेंस कॉन्ट्रैक्ट, सो दीज आर द थिंग्स व्हिच विल हेल्प यू। ओके, so intimation to police, POXO Act. What POXO Act says? Protection of child from sexual offenses. It is not POSCO. It is a POXO. Okay. 2012 amended in 2019. What it says? Any patient who is less than 18 years, if she is pregnant, married or unmarried, must be informed to either police or a child welfare committee in written format at that moment only. If a patient comes to Lonikar sir and Lonikar, because lump in abdomen is sent to Lonikar sir की 16 साल की बच्ची सर देख लेना एक बार, Lonikar sir come to know क्या रे इसको तो प्रेगनेंसी है, at that moment Lonikar sir should inform the police कि वो gynecologist तो बाद में बताएगा, पहले Lonikar sir ने बताना चाहिए। तो whosoever come to notice that the patient is pregnant less than 18 years must be informed to the police. That is a POXO Act. अगर नहीं करते हो तो 6 महीने का imprisonment है आपके लिए। Okay, so it is a mandatory, very stringent law. Nowadays, we are in very much big trouble. Dying declaration, medical reports and forensic reports, and medical certificates, and application given to appropriate authority. Okay, so consent, I have given you the things, and this is the summary. So there are some few personal views from my side. Video consent is acceptable, but it is a double-edged sword. Why double-edged sword? Because the opposite party advocate also listens carefully. 1, 2, 3, 4, 5, 6, 7. Oh, Doctor Sahab, आपने इसमें तो ये दो चीजें बताई नहीं थी उन्होंने. So that is the proof we are giving in their hand. So it is a double-edged sword. So be careful while taking the video consent. Time to time information to the patient. Uniform consent must be used. It is very good because everything is mentioned there. आप कुछ भूल नहीं पाएंगे उसमें, है ना? तो हमको बताया नहीं, वो बताया नहीं. एक पेज इन्फॉर्मेशन का, एक पेज सिग्नेचर का है. तो यूज यूनिफॉर्म कंसेंट. Signature along with the thumb impression. Why thumb impression? Because patient may deny. I have seen so many cases that patient say नहीं ये मेरा तो signature है ही नहीं सर, इन्होंने खुद किया है. So मुझे पता नहीं. They cannot say that thumb impression do not belong to me because we can send to the expert through court. कोर्ट को बोलेंगे कि सर आपसे रिक्वेस्ट है कि आप इसको भेज दीजिए, तो द जज विल ऑर्डर कि भेजो उधर, और वहां से आएगा कि साला 10 लाख में से एक का मैच होता है, ये थंब इंप्रेशन तेरा ही है, मतलब ये सिग्नेचर भी तेरी है, यू आर हॉस्टाइल विटनेस, है ना? सो वी कैन प्रूव दैट इट इज अ पेशेंट सिग्नेचर. सो एवरी टाइम हैव अ हैबिट टू हैव अ थंब इंप्रेशन बिसाइड योर सिग्नेचर. सिग्नेचर के बाजू में उसका थंब इंप्रेशन लो, वो बोलेंगे सर हम लिखे पड़े हैं, हम साइन कर सकते हैं. उनको मतलब भैया ये प्रोसीजर है, आप साइन भी करो, उसके बाजू में अंगूठा दो. इफ ही और शी इज राइट हैंडेड, उसके लेफ्ट थंब इंप्रेशन लो. इफ शी इज लेफ्ट हैंडेड, उसका राइट थंब इंप्रेशन लो. इसमें नीचे लिखो कि लेफ्ट थंब इंप्रेशन और राइट थंब इंप्रेशन, और साइन के नीचे एक एडिशनल आपको टिप दे रहा हूं. सॉरी, साइन के नीचे पेशेंट को बोलना कि भाई तेरे हाथ से तेरा नाम लिख नीचे, बिकॉज दे कैन नॉट डिनाई कि ये मेरा हैंड राइटिंग नहीं. सिग्नेचर डिनाई कर सकते हैं, हैंड राइटिंग भी डिनाई नहीं कर सकते. कोर्ट के थ्रू हम उसको एक्सपर्ट के पास भेज सकते हैं. सो थंब इंप्रेशन एंड देयर हैंड राइटिंग, दे आर वेरी मच यूजफुल टू द डॉक्टर्स. फाइन. अच्छा, उसमें अभी फोटो ऑन वेबकैम, आधार कार्ड, ड्राइविंग लाइसेंस और पासपोर्ट. रेशन कार्ड इज नॉट एक्सेप्टेड बिकॉज उसमें फोटो नहीं आएगा. फोटो आईडी चाहिए कि दिस इज अजय माने, दिस इज डॉक्टर लोनीकर, दिस इज डॉक्टर मिन्ने, ठीक है ना? तो यहाँ पे तो नाम तो नहीं लिखा होता, तो इसलिए फोटो आईडी चाहिए. एंड व्हाई सो? So that nobody can deny that the signature was taken on blank paper or it was taken in hurry. ठीक है नहीं? तो ये तो मैंने आपको यूनिफॉर्म कंसेंट का भी बता दिया। पीसीपी एंटिटी में कौन से डॉक्यूमेंट लगेंगे? सो दीज आर द डॉक्यूमेंट्स। कंसेंट ऑफ सेक्शन रेडियोलॉजी, ये पूरा रिटन कंसेंट लगेगा। ये कुछ एग्जांपल से एमटीपी में इतने फॉर्म्स लगते हैं, उसमें फॉर्म सी आता है कंसेंट का, बहुत जरूरी है। फॉर्म 1 इज ओपिनियन फॉर्म एंड बियॉन्ड 20 वीक्स के आगे है तो फॉर्म ई लगेगा उसमें, एंड 24 वीक्स के आगे है तो उसमें फॉर्म डी लगेगा, वो मेडिकल बोर्ड का। कंज्यूमर प्रोटेक्शन एक्ट में पेशेंट कैन सू यू विद इन 2 years, बट नाउ आफ्टर अमेंडमेंट इन 2019 they say that patient can sue you after 5 years also if the judge thinks कि अरे ये तो बराबर है पेशेंट का, उसको टाइम नहीं मिला 2 साल के अंदर, अभी तो फाइल कर रहा है केस, इसको एक्सेप्ट करना चाहिए। तो द कंज्यूमर प्रोटेक्शन एक्ट कमिटी जो है, डिस्ट्रिक्ट कमिटी या स्टेट कमिटी, दे कैन एक्सेप्ट आल्सो आफ्टर 3 years, 4 years and 5 years. That is a very dangerous situation created for the doctors. So कंज्यूमर प्रोटेक्शन एक्ट में आपको ये करना पड़ेगा आपके लिए, इसलिए 2 साल तो आपका है। ऑपरेशन थिएटर डॉक्यूमेंट्स में क्या क्या आएंगे? कंसेंट इन प्रॉपर परफॉर्मा, देन ऑपरेटिव नोट्स बाय ऑपरेटिव सर्जन हिम और हरसेल्फ, उनकी हैंडराइटिंग में होनी चाहिए उसमें, है ना। मेरा असिस्टेंट लिखेगा, नो, उनको लिखने को बोलो। एनेस्थेसिया नोट्स बाय एनेस्थेसियोलॉजिस्ट, ये दोनों का टाइमिंग सेम आना चाहिए। आई हैव सीन फ्यू पेपर्स वेयर सर्जन सेड एट 8 o'clock पेशेंट वाज फाइन and anesthetist says patient was pulseless. So the judge said ki there is a controversy in the time, so you are at fault. Okay, so I have seen cases, that's why the time must be same of both. वो तो 99% तो सेम ही रहेगा, पर वो कभी कभी गड़बड़ में आगे पीछे हो जाता है, तो डोंट डू दैट। ड्रग्स एंड इंजेक्शन चार्ट बाय नर्सिंग स्टाफ, इंस्ट्रूमेंट्स एंड मॉप काउंट रिकॉर्ड्स, पहले कितना था वो कॉल रहता है ना, बिफोर इंसिजन, कंप्लीट होने के बाद में, बिफोर द क्लोजर ऑफ द इंसिजन एंड बिफोर लिविंग द ऑपरेशन थिएटर, उसमें 4 काउंट आएंगे, 4 काउंट रिकॉर्ड पे ले लो उस पे, और पेपर पे लिख इंस्ट्रूमेंट। शिफ्टिंग नोट्स, शिफ्टिंग करने के बाद में पेशेंट का पल्स, बीपी, रेस्पिरेशन, ऑक्सीजन सैचुरेशन पूरा पेपर में लिखना है शिफ्टिंग करने के बाद में। सो पेशेंट शिफ्टेड इन वेल कंडीशन, वहां पे है पोस्ट ऑपरेटिव रिकवरी रूम्स में, वहां पे जो राउंड है रेगुलर, नर्सिंग स्टाफ मस्ट बी अकम्पनीड देयर विद द पेशेंट्स। ऐसा पेशेंट को डाल दिए पोस्ट ऑपरेटिव केस में एंड यू लीव, नो, the patient must be accompanied with the nursing staff at least. डॉक्टर हा जूनियर डॉक्टर तो वेल एंड गुड। रूम वार्ड शिफ्टिंग नोट्स एंड रूटीन डीएमओ राउंड नोट्स, वो बहुत जरूरी है उसमें, ठीक है। अभी इंडोर पेपर है, ऑर्डर्स ऑन इंडोर पेपर मस्ट इंक्लूड डेट एंड टाइम ऑफ द राउंड, है ना। हमको डेट डालने की आदत है पर टाइम डालने की आदत नहीं है, सो हैव अ हैबिट। ओके, सीन बाय नेम ऑफ द डॉक्टर्स, देन ओपीओ मींस ओमिट प्रीवियस ऑर्डर्स, नया डालो उसमें, ऑर्डर भी इंजेक्शन, टैबलेट, फिजियोथेरेपी, न्यूट्रिशन, पूरा जो भी है पूरे ऑर्डर्स क्रोनोलॉजिकल। Daily morning fresh notes must be there. That is, and these are the conditions. A separate consent for anesthesia, blood transfusion, it is a repetition. So this is the slide which is very important. How many years you need to maintain the records? Delivery 20 years, indoor paper 3 years, by MCI rules, MTP 5 years, PCP 2 years, Consumer Protection Act 2 years, insurance 5 years, ART 10 years, service 25 years. Okay, so this is the government letter. Court case reality, eye catching things in court during case, too much perfect record, ओ अरे साले इसमें तो एक भी लाइन कट नहीं, एक भी ओवर राइटिंग नहीं, कुछ भी नहीं, इतना परफेक्ट रिकॉर्ड कैसा? ये तो फिर बाद में बनाया हुआ, ऐसे थोड़ा सा सस्पिशन दिमाग में आ ही जाता है। सो टू मेनी परफेक्ट रिकॉर्ड, मोनोटोनस एविडेंट राइटिंग, एक ही पेन से पूरा यहाँ से ए टू जेड पूरा पेपर बाद में लिखा, वो ध्यान में आ जाता है। डुप्लीकेट केस पेपर्स, अल्ट्रेशन इन रिकॉर्ड्स, एडिशन इन कंसेंट पेपर्स, बाद में लिखा कोने काने में। दिस इज WHO सर्जिकल चेकलिस्ट, यू शुड फॉलो दैट सर्जिकल चेकलिस्ट एंड प्रोटोकॉल्स आपने करना ही चाहिए। ओके, सो सीसीटीवी कैमरास, keep good relations with the police officer, approved authority, local politicians, because they will help you in the difficult situations. Colleagues बहुत जरूरी है because they will save you in the any condition of your life. One helping agency, this is the bad referral. See, बच्चेदानी की ultrasound, very bad referral. Guarantee certificate, don't give it. And the final word, whatever you have written down on the paper in a proper manner is only considered as done or performed. Though you have done many efforts and did not write it, then it is considered as not done. So you'll be at the negligence part. Okay, so please write it down. मैं तो अभी बीवी को खाना परसो बोलने के बाद में भी लिखता हूँ, खाना परसो मैंने बोला बीवी को। Okay, take it on a lighter note. Remember, the biggest lie I tell to myself that I don't need to write it down, I will remember it. So checklist or notes are very essential, or you need 2 brains. So take an assistant with you and take home messages. Be attentive at work, listen carefully, follow all protocols, write it down, and keep friends So, and if need, I am always there. Lonikar sir is there, Minne sir is there. You can take help of anybody if you की लंबी कतारों से मतलब नहीं, कोई दिल से हो मेरा तो एक शख्स ही काफी है. And who is that शख्स? Your colleague. So don't talk loose about your colleagues. Help them because they will come to help you if needed. Walk a mile to avoid a fight. But when one starts, don't back down an inch. अगर पेशेंट ऐसे मारामारी करने वाले पेशेंट रहे ना, तो आपका भी एक फोर्स बनाओ. That is your right. Protection is your right. ऐसा नहीं कि पेशेंट मार रहे हैं हम लोग, नहीं नहीं मार खाएंगे. No, आप भी दो उनको ऊपर से. ऐसा नहीं. You are treating the patients, है ना? आपने गलती कुछ नहीं किया. This is women empowerment. In last presentation I have shown you. So thank you very much. Thank you, Lonikar sir, for giving me the chance here to present. I'll stop sharing.
Thank you. Thank you very much, Dr. Ajay. It was very much liquidity and useful talks, both of your talks. And in near future, we will be implementing or launching our teaching modules in medical legal sort of things across India, and those will be online courses. There are 6 to 7 modules, that is clinical processes, non-clinical processes, administrative processes, as I earlier mentioned in my talk. So we will be updating all of the delegates regarding those teaching modules, which will be online, and we will be providing ready-made formats for that thing. And if anyone needs any personal sort of consultation, please contact Dr. Ajay Mane on his given numbers, or Dr. Iqbal Minne sir. They are regularly providing personal consultations in case of any litigations they are facing. So with this note, we will be closing down this session. I thank all the delegates and Dr. Amit also for his great help in technical things. And Dr. Iqbal Minne sir and Dr. Ajay Mane sir. Thank you very much, and see you in near future. Thank you. Thank you.
Thank you. Thank you, Pramod sir. Thank you, Amit bhai, for your help.